bench right now. Can you see me after? The judge wants to take the bench. Okay.
All right, court's back in session. Remain seated, please.
Okay. Good morning, everyone. Please be seated. Having a hard time seeing Mr. Claypool. There we go. Behind the screen. Okay, are the parties ready to go? Well, by ready to go, we've got some things we have to do, but I'm saying we're ready to get started here. Well, that's okay, but let me ask this question first. Is the defense proposing to present any additional evidence at this time?
No, Your Honor.
Okay, so when the jury comes out, defense is going to rest, is that right?
Yes, I just want to, I guess, renew one issue with Dr. Walker before we rest.
Okay.
It'll take me 30 seconds.
That's fine. I'm going to give you a chance to do all. I'm just trying to do a little planning here because I've got the jury sitting out there for
no
next.
more witnesses.
Okay, so there'll be no more witnesses. You're going to make a little additional argument with respect to Dr. Walker. Is it appropriate for me to have the colloquy with Ms. Dippolito now before we bring the jury back out and you rest?
Yes, Your Honor.
Okay. Do you mind doing that now, or technically you rest, or you don't rest, but I would wait until you're at the very end. If you're at the very end, even though you're going to make some additional arguments, I like to get the colloquy out of the way. Is that all right?
I think it's the same
Okay.
either way, so we're fine with that.
Okay. So why don't we get the microphone to Ms. Dippolito. All right. You can sit. You don't have to stand if you don't want to. I'm okay as long as I make eye contact. Would you please raise your right hand for me? Do you swear or affirm the evidence you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. You may put your hand down. Just for the record, go ahead and state your full name for me.
Dalia Dippolito.
Ms. Dippolito, what I'm going to do at this time is to have a conversation with you concerning your right to testify or not testify in this case. And the purpose of this conversation is twofold. Number one, to make sure you understand your rights, and then number two, to make sure that on your own behalf you're exercising those rights. So the first thing I want to do is explain those rights to you just to make sure that you understand. You have the right to take the stand in this trial and testify in this case, or you have the right to remain silent. And should you exercise that right, this jury is not permitted to infer guilt from that and is not permitted to use that in any manner whatsoever, and I shall so instruct the jury if you exercise the right in that manner. Do you understand that you have both the right to testify and not testify in the case?
I do.
Okay. Now, do not tell me what you spoke to your attorneys about, because that's privileged. I don't have the right to know that. I just want to make sure that you've had, in this case, at least the opportunity to speak with your attorneys concerning whether you should testify or not. Have you had that chance?
I have.
Okay. Now, one other thing I want to tell you about the right to testify. There are a lot of decisions that your attorneys get to make for you. Those are called strategic decisions. But there are some decisions which are fundamental, which means that you have to make those decisions for yourself. Your attorney or attorneys cannot make those decisions for you. The right to testify or not testify in a criminal trial is a fundamental decision. And what that means is that you have to decide that for yourself. Do you understand that?
I do.
Okay. And for yourself, have you made a choice here as to whether you wish to testify or not testify in this case?
I have.
And what is that decision?
Not to testify.
Okay, very good. You have that right. I'm going to instruct this jury they cannot use that in any manner whatsoever. Okay, thank you for allowing that at this time, Mr. Rosenfeld. You want to go ahead? If there's an evidentiary issue you want to bring up, go ahead.
Yes, Judge. First, we're going to renew our motion to suppress subsequent to Mr. Shihade's testimony. He did testify that he knew there was a security device in his car that was an unrecorded device. He had no knowledge of the camera in his vehicle. We obviously disagree on the law here, but I would argue, based on the case law I provided you, that it specifies silence surveillance video. That's the case with the dentist. And in this case, it was a video camera that captured audio and video. So we'd argue that that should have been excluded. And in light of that not being excluded, Your Honor should grant a mistrial.
Okay, the motion for mistrial is denied and the motion to suppress, as I've indicated to you before, It is the capturing of oral communications, which is covered by the statute. It requires a consent. A consent was given. Video is not required for consent. That's why the form says oral communications based on the evidence presented. I'm going to deny the motion to suppress again, and also the motion for mistrial. What was the other evidentiary issue?
Just regarding Dr. Walker, and I guess to clarify our position quickly from yesterday, most of the discussion was based on how it applies to our theory of defense. And I think that's the confusion the two of us have been having, I guess, in our dialogue back and forth, and maybe the problem I've been having in explaining my argument to you. Relevance is not just to prove a material fact, it's to disprove a material fact. And the state, it goes without saying, is going to argue in closing certain facts they've elicited through testimony, such as Sergeant Ramsey and his cross-examination that she didn't show any tears when he approached her, or that she was faking her emotions during the interrogation, or as I discussed yesterday, she didn't look afraid. Now, believe it or not, when I found some free time between filing motions and filling your Honor's inbox, I found, I read some comments online about this case, and one thing that came up several times that intrigued me was people saying, well, if she was the victim of domestic violence, why wouldn't she go to the police? Why didn't she go to the police herself? And Dr. Walker, in our opinion, is entitled to disprove a lot of these facts, not specifically as it relates to this case, but to clarify a lot of things about battered woman syndrome and why women in general don't do things like go to the police when they're being abused, why women may act a certain way during interrogations when they were victims of domestic violence. Why? These are general concepts that relate to battered woman syndrome. The state's going to get up there and, like I said, argue she lied, she was faking all this, she wanted him killed, and we're completely, hamstrung from disproving any of this. We have no way to disprove any of their allegations or give an explanation for it.
But there can be no evidence before this jury. There are two levels to this. First level is because she can't testify because he did not subject Dippolito to examination, because she cannot testify that Dippolito even saw battered woman syndrome. Those opinions would not be relevant. You couldn't tie them together. If you give testimony generally, again, going back to the point I made yesterday, that would mean that even though there's no defense that goes to the subjective state of mind of the defendant beyond intent, you can't offer it for intent because that would diminish capacity of it. In every case, you come in and just say, well, you can give the general characteristics of a person that has either battered woman syndrome or, as the doctor testified, actually PTSD, and suggest that they acted in a certain way because of that or didn't act in a certain way because of it.
That's where I think I was, I think that's where I guess, I didn't clarify my position yesterday, is we're not saying, we're not using it to argue intent. The state's arguing this was her intent, and we're just giving an alternative explanation to this. We're disproving their facts and saying, no, the fact that she acted this way.
I understood your explanation yesterday. I wasn't,
I
didn't misunderstand your argument at all. It's the same argument you made yesterday.
And what I just said wasn't going to the specific facts of the case. I was saying she could educate the juror on general principles about why people don't act that way.
I understand. That's the argument you made yesterday. I mean, believe it or not, I'm not the sharpest knife in the drawer, but I understood yesterday. I mean, I did. I understood that argument. You made that argument. I consider that argument, and I rejected that argument for the reasons I stated before. So I didn't misunderstand you. I understand the distinction you're trying to draw. I just don't believe it's a legal distinction which will allow this witness to testify.
All right, and obviously the constitutional basis for our argument, both state and federal, would be due process, right to present a defense, compulsory process.
I know that's a go-to argument, but due process does not, you still have rules of evidence.
Correct, Judge. And, we would just argue that the state has been given a lot of latitude in presenting their case here. And, in a situation like this, we should be given some latitude in rebutting the claims they've put forward.
Okay. All right. Are those the evidentiary issues you want to address?
Yes, Your Honor.
Okay.
There's a third issue that's not evidentiary, a motion I filed last night.
What motion is that? You filed several motions.
Oh, not pertaining to the jury instructions, pertaining to... Fumble my way through here, Judge.
The sleeping juror?
Yes, Your Honor.
We'll address that later. I'll tell you why.
Okay.
Just so you understand,
No,
okay? Throughout the entire closing argument, I don't want to take up time now because I got jurors waiting. The alternates are going to be here, okay? This becomes relevant when I send them back, okay? So what I'd rather do is, rather than keep jurors waiting while we're doing all of this, I'll work out something over our lunch break to hear what you have to say. I'll give you my general observations, but it's not going to prejudice you because they're all going to be here until I send them back. I don't discharge alternates till the very end. So we'll get to this.
That's fine, Judge.
Okay?
Thanks.
Okay, can we, you also, obviously, when you close in front of the jury, you have the right, obviously, to argue and should argue for your renewed motion for judgment of acquittal. Do you want to do that now, even though you have not formally rested in front of the jury?
She has to rest first.
She does, but you can also agree to make the argument now. I mean, all I would do is bring the jury out, you would rest, and I'd send them back. We can do that if you want, and I can send them downstairs for a few minutes to get coffee, because we still have to do the charge conference. So if you want to do that, that's fine. I think they're here. Neil, are they back there?
They are, Judge.
Okay, so we could bring the jury out.
If we could, I just want to collect my notes for JOA before.
That's fine. And that way I won't keep them wrapped up in this jury room any longer than necessary, and we'll get an estimate. How long do you think after you rest it's going to take to argue the remaining issues we have here? We've got jury instruction issues. It seems like we should be able to do that fairly quickly, right? Because they're all things I've heard before.
I would say 10 minutes.
Okay. All right, let's do this. Well, let's go ahead and let you rest formally in front of the jury, and I'll send them back. I'm going to keep them back there, though, because I think we ought to be able to get ready to go pretty quickly. Just so you know, we have given them menus, and we plan to buy them lunch, so we'll probably end up, as I indicated to Mr. Claypool last night when I was trying to figure out scheduling, we'll probably end up taking a short lunch, let them eat, but keep them in there, and then continue with the closings after that short lunch. But let's go ahead and let you guys rest, and then we'll talk about the instructions. Council may be seated. Welcome back, ladies and gentlemen. Appreciate your patience. At this time, does the defense have any additional evidence or witnesses they wish to present?
No, Your Honor. Defense rests.
Defense rests. All right. Ladies and gentlemen, the evidence is all in at this time. I just brought you out, but I'm going to send you back in for a couple of minutes. And I'll tell you, I have to go through a couple legal issues and get ready for the closing. So it's going to take us a couple of minutes to do that. I'm hoping to do that relatively quickly, so I'm going to keep you in the jury room while we do that. So we'll be bringing you out in just a couple of minutes. We'll get through these issues as quick as we can. So I apologize for bringing you out and sending you right back in. All right, counsel, you may be seated. Mr. Rosenfeld, you want to go ahead and do your renewed motion for judgment of acquittal?
Yes, Your Honor. At this point, defense would renew its motion for judgment of acquittal under the second standard regarding no reasonable juror. And it's two parts, Your Honor. First, regarding intent. We believe the state has not established intent. No reasonable juror could find that Ms. Dippolito did intend to prove this crime, and for several reasons. First, following Mr. Shihade's testimony and them laughing at him after she allegedly committed this crime. That goes against intent. Secondly, allowing Ms. Dippolito to go home night after night after night. Third, the testimony that after she allegedly committed this crime, for 2 nights in a row, she's permitted to go home and they do nothing to prevent her from seeing Mr. Dippolito or anything else, putting no surveillance on him. But I think the facts and the incredible testimony put forth by both Officer Moreno, Stephanie Slater, well, mostly Officer Moreno, indicates that there is not sufficient evidence to establish intent, for a reasonable juror to establish intent beyond a reasonable doubt. Secondly, we believe they could not disprove objective entrapment. Now, you know, I stand firm on the fact that that is an affirmative defense in Florida. I recognize Your Honor's position and respect it. However, while there is a plethora of case law indicating that it is an issue of law and subjective entrapment is an issue of fact, I am yet to find a single case in the state of Florida saying that it cannot be an affirmative defense.
Or that it can.
Correct. Well, no, incorrect.
Well, no,
And this is,
you're going to cite the 2 cases
No,
in dicta where they talk about it.
I wouldn't say it's dicta, and this is why. There was 3 issues in Delis that were decided by the court. It was reversed on one of those issues, but they addressed all 3 issues. And the third issue, and I think this is where we disagree, and I've been through this time and time again reading the case, and I don't think it's dicta, is when they talk about the objective entrapment argument, and that should be an issue for the trier of fact when there are factual issues in dispute. They actually, they make a ruling based on that. Obviously, the case isn't reversed on that ground, but I think they do establish a settled principle of law there. Now, I understand Your Honor's position, and I think, you know, in this case, it is a fine line, but in a situation like that where the Fourth has addressed, at least in some capacity, the issue, this court is bound by that, and they are bound by the Fourth. And I'd argue that in light of that, it is the same standard as Iowa and a few other states cited in the motion, where it's both a pretrial issue when there are no disputed issues of fact and an issue for the finder of fact when there are disputed issues. And in this case, it goes without saying, from the pretrial motion to dismiss, that there are disputed issues. I mean, Your Honor did acknowledge in your order that there were disputed issues. I mean, I think we're not going to disagree on that point, but we'd rest on that, Judge, and move for a judgment of acquittal on those 2 grounds.
Okay. Brief response by the state. I can't hear you.
Resting on the evidence presented, sir.
All right. Okay. The arguments you made with respect to intent are going to make fine points in closing argument, but I think we have a jury question on the issue of intent. Objective entrapment, you know, I've made my ruling on that. If the Fourth, in my view, in my humble view, wants to make new law on that, they can. This could be a test case for that. I don't know whether they would address it. And again, it's only relevant if there's a conviction. If there's no conviction, it's no issue. And if it's a hung jury, you guys can find another judge to try the case again, because I'm out. But in any event, with regard to objective entrapment, my analysis remains the same. First of all, entrapment in the state of Florida is initially controlled by statute. The legislature has actually defined what entrapment is. After the legislature passed that statute, our Supreme Court came in and said that there's a limited exception, because before that, my understanding is that there was a concept of objective entrapment which might be submitted to a jury. Now, I don't think it's quite what you've proposed, but after that statute, it was supposed to, in terms of entrapment, that was supposed to define the law of entrapment in the state of Florida. Supreme Court came in and said there is a limited exception to that, which is the concept of objective entrapment. And if you look at the Supreme Court precedent, which establishes that, it clearly says the reason we can create this exception, because the legislature has said otherwise, the reason we can create this exception is because we can rely on the Constitution. And we can rely on the Constitution because we can call it a due process violation. I'm paraphrasing, this is exactly what they said, but they basically found that objective entrapment nevertheless exists in the state of Florida because it would be a due process violation, and a court could determine a due process violation, determined based on police conduct that it was so outrageous that concepts of due process would prevent the case from going forward and deny the state the right to even prosecute. And that's the core of objective entrapment. They get denied. The remedy is the court hears it and says, you can't even go forward. To recognize the objective entrapment defense as you've proposed it, and maybe the fourth will, I don't know, like I said, this could be a test case, would be to suggest that in every criminal case, a criminal defendant, without raising subjective entrapment, can basically say, you know, the police acted outrageously here, let's get an objective entrapment instruction and place that issue in every criminal case before a jury. I don't believe that is either the intent or the holding of the Supreme Court. And I do recognize the statement that was made by the fourth. I can just tell you that many times, because I've sat there, you have to be careful with your words. Sometimes you put something in an opinion which people later run with, and it really isn't what they're trying to say. So again, this may be a new issue. You may be able to create new law in the state of Florida, at least from my perspective. But I think Supreme Court precedent in this state, construing the statute, construing objective entrapment as a due process violation, that it's clearly an issue for the court and not the jury. That's my analysis. Now, if I'm wrong, you and I have agreed to disagree on this issue all the way through. And if I'm wrong, the fourth has, you know, they will reverse me like they'll reverse anyone else. So if that's the case, they'll reverse me if it becomes an issue. So that's my position on that objective entrapment is not for the jury, subjective entrapment is. So I'm going to deny your motion for judgment of acquittal on that grounds also.
Well, I think while we're, you've denied both, and I think while we're addressing this point quickly, we might as well just, or I might as well add two arguments to permit it for purpose of the, or I guess to argue for my requested jury instructions. We're already in the middle of the discussion, so.
You might as well.
why re-raise it? And I think the last two arguments I'd make is, and I believe, without having the motion in front of me, was Ruiz was the case, the first case to address subjective entrapment when Florida adopted the statutory subjective entrapment. And I might be wrong on the name of the case, but that sounds somewhat familiar. And Ruiz, and so did you know, the other states that have adopted my analysis, and there are 3 different positions that states have adopted throughout the country. My analysis being one of them, they stress the importance in these states of placing a check on police misconduct. And that check extends well beyond just the judge, also the jury, you know, as the fact finders. Now, also, if you look at case law in Florida regarding other issues, let's say C4 motions, when there are factual disputes, it is an issue of fact for the jury. Now, by way of example, and you know, I agree there is a difference here, but there's also a similarity when it comes to stand your ground motion, which is statutory, and I recognize that. It's an issue of law, pre-trial. We have a second opportunity to argue that to the fact finder.
But it's, okay.
And I know one's constitutional, one's statutory.
Totally different. So the right of self-defense has existed for years. Before there was a stand your ground statute, there was a right to raise with a jury self-defense. It was always a jury question, self-defense. Stand your ground is a statutory, it is not a constitutional principle. That's why if you testify in a stand your ground hearing, that testimony can be used against you at a trial because you're not protecting a constitutional right. It's a statutory immunity that's been created by the legislature.
No, as I said, I recognize that distinction exists. What I'm saying is it's not an anomaly for defendants to be able to argue something pre-trial, for a judge to make a pre-trial determination as to bar prosecution, and then for defendants to be able to argue an affirmative defense.
No,
even though it stems from different grounds, and I recognize that.
Make your argument for you, but I still don't think it applies.
Sure.
To make your argument for you on a motion to suppress a statement of a defendant for violation of due process, Miranda or not voluntary. That's a situation where you're correct. I can deny a motion to suppress, but the jury still gets to decide whether it was coerced or voluntary. I understand that. I just don't think those principles apply here. That's all I'm saying.
Okay, and like I said, I'll rest on the when there's a mixed issue of law and fact. it is an issue for the fact finder. And there is case law on, like I said, C4 motions, and I put those in in the motion provided to the state and the court.
Okay, so basically what you're addressing is the jury instruction argument too.
Yes, and I'm renewing, so basically I'm moving for a special jury instruction. You already denied the objective entrapment JOA, and I am renewing my motion to dismiss based on objective entrapment.
So I'm going to deny both those requests. You can file, though, make sure you file your requested jury instruction on objective entrapment with the clerk so that the fourth understands what I denied.
Yeah, the request is filed, and I'll give you a copy of...
I'm just saying, just make
Yeah,
sure
sure.
you got your record preserved.
And we'd also, the last motion we'd renew is our motion to dismiss based on lost or unpreserved evidence. I think in light of Mr. Shihade's testimony, Captain Bonifaire, Mohammed Shihade has been consistent, in my opinion, about him being wired, and the fact that he came out and they had critical information pertaining to, or not critical, but specific information pertaining to what happened inside of Chili's indicates and proves that there was evidence. In this case, that they knew that Ms. Dippolito ordered a meal to go for Mike Dippolito. And
Let me tell you how I feel about that. The state's going to need to get up here in a minute because this is going to affect the jury instructions, okay? If you're moving to dismiss based on Arizona versus Youngblood, in other words, lost evidence, that's going to be denied. There's not sufficient evidence that such documents existed, and at best it would be considered potentially useful, and you'd have to show bad faith. And so I'm not going to dismiss the case based on an Arizona versus Youngblood analysis. However, I believe that you may be entitled to a modified lost evidence instruction.
based on Davis?
In the jury instruction. Well, here's my feeling, okay? And I don't know who's arguing jury instructions for the state.
And one other point, Judge, regarding, just for the record, I know you've ruled, you said potentially useful. We would argue materiality based on, based on his testimony about her being a little off.
Yeah, but there's no evidence presented.
Oh, I understand
trial
that,
that
but
it could be that it's material exculpatory evidence, because he testified that when he came out, Mr. Williams asked him, he didn't threaten, he didn't coerce, he didn't pressure her during that meeting. There's no evidence that suggests that that recorded meeting would have produced material exculpatory evidence, and that would be critical to a motion to dismiss. Otherwise, it's just potentially useful under Arizona versus Youngblood, and then you have to show bad faith. To show bad faith under the Florida Supreme Court case law, you have to show that officers knew that it was exculpatory and intentionally destroyed it. I mean, that's the analysis under Arizona versus Youngblood.
yeah, we would just submit that based on his limited testimony that she was off, and I mean, there was a little more, and I don't want to misquote, but, you know, in the fourth will hopefully not have to rely on it, but if, God forbid, they do, they can rely on Mr. Shihade's testimony, that it was material. That makes it material. And based on the conflicting testimony of all the officers and Mr. Shihade, I think that's circumstantial evidence indicating that it was in bad faith, that there is some sort of cover-up.
I don't think there's enough evidence
Okay.
to do it Arizona versus Youngblood. But here's what I have thought about and what I think you may be entitled to. I think you've at least put forth enough evidence that you can argue to the jury that because of what you just told me, that there was evidence that Mr. Shihade was wired when he went in. There was some evidence that he testified that the officers overheard what he was saying. I think based on that, you probably have a good faith basis to argue that there was a tape and it had been lost or destroyed, and that then becomes a fact question for the jury. And so what I believe you're entitled to is an instruction which in my view correctly states the law, and you and I may disagree about this, because you think that you can get a lost evidence instruction even if they failed to capture evidence. I don't believe that to be the law. I believe that evidence must at once exist and they've lost or destroyed it. But you have enough evidence in the record where in good faith you can argue that it existed and they lost or destroyed it. And so the instruction, the modified instruction I think you'd be entitled to is not the instruction you prepared, but I prepared one. I'm going to give it to you. And it makes clear what I believe to be the correct statement of the law, and it gives you the opportunity to argue, and obviously the state can argue against it, but it also gives you the I've got extra copies. Let me do this. 2 for you, Mr. Williams, 3 for this.
I actually prepared
You got a new one?
instruction that I thought would be consistent with what you.
You got another one? All right, let me show me what you've got.
This might be almost identical.
Actually, I took away my only copy. Can you give me back my copy?
That actually is identical.
Really? We agree.
Except for like the phrasing at the beginning, the actual law is. Well, no, I maintain my position that failure to collect or gather, that we
Right.
should be entitled to that instruction, but in
What-
light of your Honor's ruling that gathering is not the same as preserving, despite the distinction I put forward in one case.
Right. Failure to gather, I don't think gets it. I think
So you're
existing
overruling
and
any
destroying.
instruction involving failure to gather? Or you're
Yes.
denying that? Okay, so
Yes.
in light of that, we'd propose this instruction, which is very similar to yours.
It is. I like mine better, obviously. Mine just says if you find that evidence existed at one time and you find that the state has allowed that evidence to be destroyed or lost, you may infer that the true fact is against the state's interest.
We're fine with that, Judge.
Because I think you can argue, again, based on this, the state will argue otherwise, but I think there's enough evidence here that you can argue, if you wish, that evidence did exist at one time, and if the jury finds that it did exist at one time, then they're permitted to use this inference. So I think based on the evidence presented, you're entitled to this instruction. I'm going to give it.
We're
Does the
fine
state
with
have anything you want to say about that? Okay. All right. One other thing I want to cover before I get to any other issues that the parties may have. I just want to do this for the record, and I think, Mr. Claypool, you indicated this the other day. You were in agreement, but just want to make sure it's on the record what we're talking about. Remember last night we talked about the fact that generally anytime you define first-degree murder in the state of Florida, you're required to give, and I'm going to just cite for the record what they are, you're entitled to give, you're required to give standard instruction 7.1, which is an introduction to homicide. It talks about justifiable homicide, it talks about excusable homicide, and then it defines first-degree murder. I think we're in agreement, but I just want to make sure it's on the record that the defense is waiving introduction to homicide, justifiable homicide, and excusable homicide because you do not like the repeated use of the word killing in those instructions, and you're fine just using a definition of first-degree murder because this is simply a solicitation case. It's not actually a murder case. Is that
Yes,
correct?
we affirmatively state that.
Okay, all right. So I just wanted to make sure that was clear because we had that big discussion last time, and I want to make sure we're on the same page there. Okay. Are there other issues with the jury instructions that we need to cover?
Just my general objection that I make every trial, that not guilty should be in front of guilty in all instructions and the verdict form because she is presumed to be innocent and the state does carry the burden.
Okay. I'm going to use it as we normally do, so I'll overrule that and prepare it as I normally have. Other than that, are there any other changes to the jury instructions from last time?
No, sir.
Does the state look them over? Okay. I'm sorry? Okay. Now, the only thing that's going to be, that's not in your instructions right now, I've already done it, is the lost evidence instruction I just gave you. I've already included it. I thought the best place to put it is after weighing the evidence, so I put it after weighing the evidence.
What was that, Judge?
The instruction I'm going to give on lost evidence, what I'm going to do is in just a moment I'm going to give you a final copy of the instructions. I'm just telling you where I put it, okay?
I think that.
Right after weighing the evidence and before defendant not testifying, I put your lost evidence instruction.
That's logical, Judge.
Okay. So what I need you to do then is give me just a couple of minutes. What I'm going to do is print the final copies of the instructions. I'll get each of you a final set, and we'll make copies for the jury. Where do you want your warnings? I know we talked about 2 hours for closing. State, how are you dividing your time?
Yeah, Judge, I would probably take an hour and a half and Mr. Williams a half an hour. Obviously, if I don't take my whole time, it would roll to him.
Right, but your plan is 90 minutes and 30 minutes. On the 90 minutes, where do you want your warnings?
5 and 2.
5 and 2. Mr. Williams? She can say, shut up and sit down? Okay. All right. Mr. Claypool, where would you like your warnings?
10 minute warning.
Just a 10-minute? Okay. All right, give me just a minute. I'm going to go get these jury instructions finalized, and we'll get ready for closings. I would order lunch. Seated. All right, let me hand these out. Where's Neil? All right. He's probably handling menus. Can you do me a favor then? And I'm going to give you 8 copies of the jury instructions if you will put them on the jurors' chairs. You will do that for me. And then let me know if I gave you one too many. Apparently I can't count. I have copies of the jury instructions for both sides. Did you have an extra? Yes, sir. Yeah, that's my, put it over here. Defense gets 3 copies, state gets 2. Let's put this on this side. That's that.
This is defense.
Yeah, but they get an extra one. There you go. And then I also have copies of the verdict form for both sides. Again, 2 for the state. I'll just let you divide them up. 2 for state, 3 for defense.
So you're still crushing the bench. How you doing, man?
Not yet. Do you know, did Neil? Okay, so you're able to bring out the jurors if necessary. Let me make sure they're set up though first. You guys let me know when you're ready to go.
Are you reading first or after?
I read 90% of it before and a small section after. Let me just do one thing before. Well, this goes to both state attorneys. I just want to make something clear on the record, okay? I Just don't want to, I don't want to anticipate something that's not going to happen, and on the other hand, I don't want to say something when I should have. Please understand, and this is directing the state in terms of their closing arguments, any evidence with respect to the attempt to poison Mr. Dippolito was admitted for impeachment purposes only. And what that, okay, and then what that means is, but so Mr. Rosenfeld knows that doesn't mean they can't mention it. It means you cannot argue it that she tried to poison her husband as a substantive fact. The only way it can be mentioned, and they can mention it in terms of impeaching Mr. Shahadi's testimony. They can say, you know, he testified to this, but understand he said this. I mean, so that's how it can be used. I think everyone's clear. There was just such a big deal about this testimony. I want to make sure everyone understands the purpose for which it was admitted.
Obviously, we renew our objection, but in light of your question,
No, I know. There's really nothing to renew at this time. I'm just telling you what they can do and not do, so that you understand and they understand. I think everyone does understand. Okay, are we ready to bring in the jury or not? You need a minute to get your equipment. What, Mr. Rosenfeld? What were you saying?
The computer mouse isn't even working to be able to get the disc to play. We keep trying to restart it.
Is this the same laptop you've been using?
Yeah.
We've had it working for a while now.
Judge, along the same lines, it's my understanding based on the court's ruling that information pertaining to Larry came in for effect on the listener, not for the truth of the matter asserted. So, I mean, we went through this, although you did find it relevant, then we did the hearsay issue, then you disagreed and said it's like, or I brought up the hearsay confrontation clause and you disagreed and said it's like a police interrogation based on effect on the listener. So we'd argue that they can't argue it for truth of the matter asserted, only for effect on the listener as it is in the tape.
Well, okay.
Mr. Shihadi sat and said continuously yesterday that part of the whole reason he went was because of
Right.
Larry.
I didn't exclude it for the same reason. The tape itself is effect on the listener, but his testimony is fair game.
Correct, but he testified that his basis of that was what Larry told him, not, he said he never overheard it. I mean, he said that in
Right, but
private.
he also testified at that time, she asked, do you have someone that can kill my husband? And he said later on he went to the police because of that whole thing. They can suggest that he went to the police because of that confrontation. They can't say what Larry said because they don't know what Larry said, but that he acted based on that information. That's not just for impeachment, that is describing the basis that he acted upon. It doesn't prove the truth of the matter asserted, but it does go to the subsequent action taken by Mr. Shahadi.
Oh, I mean,
It doesn't have the same, I mean, it came in.
obviously our position is that all knowledge he has based on that comes from a conversation with Larry and inferences based on that conversation with Larry.
Yeah, but again, it describes what he did, so it's not offered to prove the truth of the matter asserted. They can't, well, to answer your question this way, I don't think they can argue that she tried to hire Larry. I think they can argue that he went to, Mr. Shahadi went to the police because of that, because that's describing the action, but there's no, it wasn't offered again to prove that in fact she was trying to hire Larry, just to describe his subsequent action. So I guess that, in part, that's consistent with your position.
My request is granted in part.
Yeah, did everyone hear that? Ms. Laurie, do you understand?
I'm sorry, Judge. Trying to multitask.
Yeah, I mean, I think the position he's taking is correct in part. You can't argue that she tried to hire Larry. What you can argue is that Mr. Shahadi reacted because of that, and that's why he went to the police.
My argument, Judge, is on that date in March, she actually asked Mr. Shahadi if he knew somebody that could kill her husband.
You can say that. That's not a problem. What I'm saying is you can't argue as substantive fact that she in fact tried to hire Larry. What you can argue is he testified that, I'm not going to go through your whole closing for you guys, but he asked, or was asked by Ms. Dippolito, do you know somebody that can kill my husband? And that based on that and the interaction he observed, he went to the police later. But you can't argue that in fact she tried to hire Larry because that hasn't been established.
2009, 4:15 p.m.
Okay, I think we're clear. You got a bunch of other state attorneys in the office, or in the audience. Anyone have a computer that works? Ms. Grimes, does yours work?
You can't disconnect this one, Judge.
You can't? Okay.
It's working. It's working, right?
Well, Ms. Grimes is coming up, but maybe she's not needed.
We can't. You can't do it, unfortunately.
The problem is that it doesn't have the driver for those.
Right.
You gotta have a specific driver for those.
For the sound system.
Yeah, or it won't
doesn't work.
play.
No, it's not. There's a driver on in the software.
So the sound's not working?
There, at least.
The sound works.
Okay, we're good.
Just put it-
Yeah, they changed the mouse. I think they changed the mouse.
The mouse? It's the mouse?
I had to take the mouse off that, put it on here.
Is it working?
Yes.
So now we're good?
I love you too.
Okay.
All right, last chance. We good?
Good, Judge.
Ms. Rosenfeld, you ready? Or Mr. Claypool? I can't see Mr. Claypool, but ready? Okay, let's bring in the jury.
You all can come on. Jury's entering.
All right, counsel, you may be seated. Welcome back, ladies and gentlemen. As I indicated, the evidence is now closed in this case. It's now time for you to receive your legal instructions. That is the law that you must follow in deciding this case, and also to give the attorneys an opportunity to make their closing arguments. Each of you should have a package of documents which starts with the title Jury Instructions. Do you each have these instructions? Okay. Just a couple words about the jury instructions. The jury instructions are essentially given to you in two phases. Most of these instructions I'm going to give to you now before the attorneys make their closing arguments. There's a small section entitled Final Instructions that I actually give to you after the attorneys have made their closing arguments. You will see that as I'm reading these instructions to you, I will get to a point where I begin to read from a verdict form. Do not frantically look for your copy of the verdict form. You do not have one. Here's the original. I'll send it back with you into the jury room when you begin your deliberations. But when I get to that point in the instructions where I begin reading from it, don't look for it. You don't have it. As I indicated, I think in my opening or preliminary instructions as the case began, I'm required to actually publish these in open court, which means I'm required literally to read these instructions to you. And so you're going to have a choice. You can simply listen to me read, or you can read along with me. But I'm now going to publish verbatim the legal instructions that you must follow in this case. Jury instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charge. Dalia Dippolito, the defendant in this case, has been accused of the crime of solicitation to commit first-degree murder. Criminal solicitation. To prove the crime of criminal solicitation, the state must prove the following three elements beyond a reasonable doubt. 1, Dalia A. Dippolito solicited Witty Jean to commit first-degree murder. 2, during the solicitation, Dalia A. Dippolito commanded, encouraged, hired, or requested Witty Jean to engage in specific conduct which would constitute the commission of first-degree murder or an attempt to commit first-degree murder. 3, Dalia A. Dippolito had the intent that Witty Jean commit the crime. It is not necessary that the defendant do any act in furtherance of the offense solicited. To solicit means to ask earnestly or to try to induce the person solicited to do the thing solicited. It is a defense to the charge of criminal solicitation if the defendant, after soliciting Witty Jean to commit first-degree murder, persuaded Witty-Jean not to do so, or otherwise prevented the commission of the offense. Murder, first degree. First-degree murder is the unlawful, premeditated killing of another human being. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity from prosecution, or hopes to gain more favorable treatment in his or her own case may have some reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So, while a witness of that kind may be entirely truthful when testifying, you should consider the testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Loss or destruction of evidence. If you find that evidence existed at one time, and you find that the state has allowed that evidence to be destroyed or lost, you may infer that the true fact is against the state's interest. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, it is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. 8, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged in the information or not guilty. Only one verdict may be returned as to the crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you. It is as follows. Verdict. We, the jury, find as follows. As to count 1, we find the defendant guilty of solicitation to commit first-degree murder as charged in the information, not guilty. So say we all this blank day of June 2017 in West Palm Beach County, Florida, to be signed by the jury foreperson. Those are the written instructions I have for you at this time. The attorneys will now